Walmart-sized rollback on things that have been overcriminalized. On top of that, we have overzealous and creative prosecutors who literally make up crimes. One of the things I talk about in License to Lie is the destruction of Arthur Andersen, the venerable accounting firm, and 85,000 jobs across the United States and other countries. It was the notorious Enron Task Force prosecutors that indicted Andersen. They did it by piecing together parts of two different statutes to make a crime out of something that was not a crime. In fact, Congress later passed Sarbanes-Oxley to fill what they perceived as the gap in the law that allowed Andersen to be reversed. And sure enough, the Supreme Court reversed Arthur Andersen in a unanimous decision that included Justice Ginsburg and others that we often rail about. But the Andersen conviction was so egregious, the decision was unanimous. The prosecutors had both made up a crime and they had succeeded in persuading a Republican judge in Houston to take all indication of criminal intent out of the jury instructions. Well, it's criminal intent that separates a crime from a civil wrong. So if you don't have criminal intent, you should not be convicted of a crime. However, no problem for the Enron Task Force prosecutors. Just persuade the district judge to take criminal intent out of the jury instructions. They could have convicted the Pope. Those prosecutors, after destroying Arthur Andersen, turned their sights on Merrill Lynch. I'm convinced that the reason they destroyed Andersen, and they knew that's exactly what they were going to do, because Andersen represented 2,500 publicly traded companies. They sealed the indictment for a week while they worked behind the scenes to avoid upheavals in the markets before they unsealed the Andersen indictment. And of course, as soon as they unsealed it, the company had to fold. I think over 160 civil plaintiffs piled on top of the criminal charges, and all their clients had already had to leave. So Andersen was history immediately upon being indicted. You don't have to worry about a conviction. All you have to do is indict. So that's what they did. And I think they did it so that they could say then to any other target, particularly a company like Merrill Lynch, you saw what we just did to Andersen. You either agree to everything we want or we will give you the death penalty. So sure enough, when they go to Merrill Lynch next, Merrill signs the most onerous non-prosecution agreement I have ever seen. They give up all kinds of rights, including of the Merrill defendants that they offered up essentially as sacrificial lambs for Merrill executives, the nicest people you'd ever want to know, were then indicted by the Enron Task Force on the offense of conspiring to help Enron or deprive Enron of the honest services of Andrew Fastow. Now, if Andrew Fastow ever gave anybody a day of honest services, that would be a newsflash.